Good morning, everyone. Good morning, India, Bharat. If you are watching this outside India, good afternoon and good evening. Those who are watching in US, thank you for joining us for this very important conversation we are having today. And today we are moving DPDP from law on paper to privacy in practice. One truth no one is talking about. Most DPDP conversations stay at theory, almost none talk about operationalization. We are changing that today. I am honored to be joined by Lagna Panda, partner at APN Partners, one of the country's most respected voices in privacy and technology law. Welcome, Lagna. Excited to bridge the law and live operation together today.
Thank you, Dr. Sahu. As always, happy to be here, happy to have this conversation with you. I think finally, after more than 2 years, the implementing DPDP rules were out in November. And while most of the substantial provisions of the law will come into effect of the DPDPA and the DPDP rules will come into effect only in May 2027, at least now we have a framework in place, and there's been an 18-month runway that's been provided for implementation. Now, while we may think that 18 months is a long time, it's actually not, because few weeks have already gone by.
Yeah.
So I think time has come for organizations to start thinking seriously about compliance and to put in place a roadmap on what milestones to achieve and what various teams and departments can sort of do to comply with this new law that the Indian government has brought in. Uh, I mean, this law is going to change how businesses function, because the obligations apply to all organizations, irrespective of their size or the sector that they operate in. Although the law provides, I mean, there are provisions that allow the central government to carve out some exemptions through executive orders.
Yeah.
But as on date, it will apply to all data fiduciaries across sectors and across businesses, across industries. There's also some amount of misconception.
Yeah.
Still, I believe that if an organization complies with the EU GDPR, then they don't really have to do anything, and their business operations, their policies will more or less be compliant with the Indian DPDPA. Now, that is not true, because while there are some very common and broad principles that are present in both the laws, both in the EU GDPR and the DPDPA, there are lots of differences as well. For instance, the EU GDPR recognizes legitimate interest and contractual necessity as valid grounds for processing personal data, but the DPDPA does not. So, if an organization is already processing certain categories of data on grounds of contractual necessity or on grounds of legitimate interest, then it will not be able to do so under the Indian law. So, the organization will have to, of course, review and assess how to, if they want to continue processing those categories of data under Indian law, how to go about it, whether they should continue, whether they can process those categories of data under consent, for which prior notice has to be given, fresh consent has to be taken, or if they can rely on any of the legitimate uses which are very narrowly defined and narrowly set out. So those decisions have to be taken by an organization. The Indian law also spells out data retention requirements, data localization requirements, which are not really there in the EU GDPR. There are additional obligations that have been set out for significant data fiduciaries. Uh, unlike unlike the EU GDPR, the DPDPA recognize does not really call out sensitive personal data as a separate category of personal data for which any additional obligation has been set out. All of the obligations that have been set out in the DPDPA apply to all categories of personal data. So there are lots of differences and nuances between the two laws. And if an organization is already compliant with the EU GDPR, they still need to do some amount of gap assessment to identify the compliance gaps, and what are the additional steps they need to take to ensure they are compliant with this new Indian law.
That's great.
So those were my initial thoughts.
No, no, I mean, absolutely, you are spot on. And here is a operational reality. DPTP workflows are daily workflows, that is consent, notice, writes, deletion, minimization, and breach task. No organizations can do these manually at scale. That's why where unified privacy automation becomes essential. So, Lagna, let me start with the most important question. With DPDP rules now published, how should organizations start thinking about compliance? Is there a practical mental model they should adopt?
Right, Dr. Sahu. Like I mentioned, I think it'll be a good idea for
Yeah.
organizations to sort of have a compliance roadmap in place on what it is they plan to do over the next 18 months. This can include, various milestones. For instance, creating data inventory, which I believe a lot of organizations have already started doing. Reviewing data flows now, data flows within the organization, within their group structure, with their joint ventures, with entities in which they have minority shareholding, with third parties. So these are different categories of data flows, and require different standards of assessment. Reviewing their own internal policies on how personal data is collected and processed, reviewing agreements that are in place with vendors, data processors, and also employment agreements, which often form the basis for processing personal data of employees. So these are certain steps. I mean, these are certain items that organizations can keep in mind when they're designing their compliance roadmap. Having said that, compliance is going to be an ongoing exercise, because businesses, are future looking. There will be new categories of personal data sets that organizations collect. Businesses might decide to launch new product lines, enter into new business segments for which they may be processing data in a very different manner. So the existing data governance structure may not work for those new product lines or new business segments.
Yeah.
So I think organizations, while designing their roadmap, should also take into account what the business plans to do in future, so that the governance frameworks and the policies and the internal processes that are laid out are future ready.
Super. Great. So let's talk about a little bit on the intent to action through automation. That is exactly why organizations struggle these days. Everyone has the intent to comply, but very few have a system to execute compliance daily. That's why the unified privacy automation converts obligations into automated workflows. So consent, notices, deletion, rights requests all run like a machine. That is why at Data Safeguard, we talk about privacy ops or privacy as a live operation, not a project, but running operational system. Our flagship product or platform, ID Privacy, automates consent, notices, rights requests, data lifecycle and deletion, vendor privacy, data privacy impact assessment, process privacy impact assessment, third party privacy impact assessment, confidential data discovery, confidential data redaction, automated DSAR, I mean, many others. So that is how the DPTP becomes doable. So, Lagna, from your legal perspective, what role does technology play in the DPDP compliance journey?
Right, Dr. Sahu. I think technology can be expected to play a very important role,
Yeah,
while efforts are being made to ensure organizations are compliant with the legal requirements set out in the DPDPA.
yeah,
For example, let's consider creating an organization is considering creating a data inventory. Now, organizations have, they collect personal data, and that personal data may be stored across databases, across systems, across departments, across teams. Tracking where personal data is stored manually may not be possible. And even if it is possible, and even if an organization sort of is able to track it and create an inventory, we don't really know what will be the accuracy of that manual inventory collection
Right.
of inventory creation. Now, similarly, if there's an access request or a deletion request by data principal, then it'll be easier. If an organization is deploying privacy tools, it'll be very efficient and a lot easier for organizations to be able to identify what or to be able to address that request efficiently, to basically identify what sort of data needs to be provided and all the information that the request form basically asks for. So responding to these requests will become a lot easier and more efficient by employing privacy tools. Now, having said that, I do acknowledge that technology is going to play a very important role in DPDP, in ensuring DPDP compliance.
Yeah.
There are a few things, there are actually more than a few things that technology cannot really do, or maybe it can sort of enable it, but it's not something that technology can design or structure. For instance, tech cannot design or structure what an organization's governance policies or internal framework should look like. Who should be the reporting person in case of a breach, how should the escalations happen, who is responsible for making reporting requirements to which regulatory authority. All of that has to be put in place in the form of a policy, and it's not something that a tool or tech can do. Or for instance, when organizations are collecting consent, creating consent records, a tool can be very helpful there to sort of create record of consent. But to ensure that when a prior notice has been given to a data principal before collecting consent,
Yeah.
whether that notice meets the legal requirements that have been set out in the DPDPA and the DPDP rules, whether all of those requirements are met or not, is something that maybe that perhaps a lawyer or the business teams are better placed to assess and to assess, and it's not really something that a privacy tool can accomplish. uh, I can also think of data processing agreements that organizations have with vendors, with data processors. And those agreements are exhaustive, and they should be exhaustive, because the entire legal obligation, and legal responsibility under India's law lies with the data fiduciaries. They are responsible for the conduct of data processes. So data processing agreement should be as exhaustive as possible. All of technical obligations of a data processor must be set out in detail. Reporting obligations of data processors must
Okay.
be set out in indemnity. An organization or a data fiduciary is also something that a tool may not be able to do. It's something humans are better placed
Yeah.
to do, and not really technology. So there's no denying that technology is going to be a great enabler for a lot of the things that organizations will have. They have to accomplish under this new law. Tech
Yeah.
will really go a long way in helping reaching those milestones and those goals. But there are quite a few things, for example, your frameworks and agreements and policies that have to be designed and structured. Those are not things that tech can sort of help you. They may be able to assist you in some way. The privacy tools may be able to
Yeah.
assist in helping you create a data inventory. But once the data inventory is created, how the assessment of how legacy data has been corrected is something that humans will be able to do better, for sure.
Yeah.
So
Yeah.
yeah,
No, yeah.
that's my thought process on where technology stands when we talk about privacy compliance.
No, great. Thank you. And as a lawyer, can you share some inputs on what are some of the things that organization must be mindful of when they are structuring their compliance journey?
Right. Like I said, when organizations are creating their compliance roadmap,
Yeah.
there are, of course, there'll be lots of items, lots of milestones that they will have to sort of set out in the roadmap. But there are a few things that they can keep in mind. For instance, if legacy personal data has been collected, and of course, all organizations will have legacy data. whether that legacy consent meets the standard that has been set out in the DPDP or not, because that will actually enable organizations to understand and identify whether fresh consent has to be taken, or whether they can just give a simple notice and continue processing data that they have already collected.
Mhm. Mhm.
While it is important that notices spell out the purposes, the goods and services that are being provided, and all of that in detail, the law also requires notices to be simple and easy to understand. So, while notices have to be comprehensive and detailed, they should also be simple and easy to understand. So, I think this dual requirement is something that's going to be interesting. It'll be interesting to see how what sort of steps organizations decide to take to comply with these requirements. uh, Records of consent must be created, and they must be kept, because uh, data fiduciaries have the obligation to demonstrate that they have actually taken valid consent. Agreements with data processors must be reviewed to ensure that your rights and obligations as a data fiduciary is where you think they should be, and there are no tweaks or changes that are required to be made. And of course, in certain cases, organizations can also consider conducting impact assessments. For example, if their operations are high risk, for
Yeah.
instance, transfer impact assessment may be helpful if an organization is, if there are significant and frequent data flows from an organization to third parties. So, for instance, on a daily basis, if personal data is that is processed by an organization is sent to third parties, for whatever reasons. So, in those cases, transfer impact assessment may be helpful to sort of ensure that data flows are happening in compliance with the new law. So these
Great
are
point.
some
Yeah.
items, yeah, that organization can sort of keep in
Absolutely.
mind when they're designing a roadmap and putting in place, what are the compliance items they need to sort of take care of.
No, no, thank you. And those are audience, if you have any questions, please feel free to comment, and we will answer you back once the live session is over. So why these conversations matter? We are not here to create fear. We are here to build capability. Lagna, as a lawyer, what do you want to say?
I mean, I just want to say that as a lawyer, lawyers are here to assist businesses in their compliance journey, and our job is to provide the right guidance, and that's
Absolutely.
about it.
Absolutely. Absolutely. Yeah. So any closing remarks, Lagna?
Well, again, like I said, DPDP is going to change how businesses operate and conduct their business in India.
Hmm.
And while it may seem like a very long road when we are talking about compliance, with the right steps and the right tools, the journey will not be a tough one. I think it's important that organizations sort of think long and hard about what sort of tools they want to employ, and how they really want to go about complying with this law. Having a structure in place will go a long way in enabling an organization which comprises several teams and several employees and several departments to sort of ensure everybody is on the same page, and things can work out smoothly.
Super, super. Thank you, Lagna, and thank you everyone for joining today. Let's move India from law to live operation on DPDP. And every week I will come with a thought leader on privacy background, lawyer background, and tech background. We will talk about a new topic on DPDP, and see you in the next session. Thank you, Lagna.
Thank you, Dr. Sahu.